18th lecture note. The title of this lecture note is Civil Law Procedure or Civil Procedure. We are going to look at this in four aspects. The first, jurisdiction and competency. The second, person participating in the case. The third, evidence. And the fourth, judicial proceedings. Let us look at the first aspect, jurisdiction and competency. Civil procedural law is a branch of law that regulates legal relations in the field of justice for the settlement of civil disputes. Like civil law, civil procedure is based on the principle of dispositivity of the parties to the relevant legal relations, which determines their procedural activity. However, the procedure of legal proceeding is regulated by mandatory provisions of the legislation. Jurisdiction is the rules for distinguishing the categories of cases that are subject to consideration in civil proceedings, that is, both civil and housing, labor, social disputes, and in other procedural forms, that is, arbitration proceedings, disputes in the field of business and other economic activities, administrative proceedings, in cases of challenging decisions, actions, omissions, regulations of government, bodies, and other public structures. Competency is the rules that determine the choice of the court that is competent to resolve a particular case. The jurisdiction of civil cases can be of the following types. 1. Birth of subject by competent court, jurisdiction of justices of the peace, district courts, courts of the Russian Federation, of the Supreme Court, the most extensive competence of district courts in relation to others according to special instructions of law. 2. The general, that is territorial, a lawsuit filed by the place of registration or location of the defendant. 3. Alternative, that is plaintiff choice, some categories of cases, labor disputes, alimony, and so on. 4. Exclusive, some categories of cases are resolved by strictly defined courts. For example, disputes about real estate are considered at its location. 5. Contractual, the parties can determine the jurisdiction of the dispute between them by agreement between them, but not for all categories of cases. Now let us look at the second aspect, persons involved in the case. The persons involved in the case are divided into two groups. 1. Acting in defense of their own interests and on their own behalf, have both a substantive and procedural interest in the outcome of the case. Parties, that is, the plaintiff and the defendant in the claim proceedings, the applicant and the interested person in the special, the recoverer and the debtor in the writ. Third parties, that is, declaring and non-declaring independent claims. 2. Acting in the process on their own behalf but in defense of the interests of other persons, have only a procedural and legal interest in the outcome of the case. Prosecutor, that is, who participates in certain categories of cases, dismissal, eviction, protection of the interests of an infinite cycle of persons, social cases, persons who apply to the court for the protection of the rights, freedoms, and legality, protected interests of other persons, or enter the process for the purpose of giving an opinion, for example, guardianship authorities. In addition, the persons involved in the case must be distinguished from those who facilitate justice. These are witnesses, experts, specialists, interpreters, court clerks, and assistant judges. Representatives occupy a special position among them in terms of the nature and scope of their powers. Now let us look at the third aspect, evidence. Evidence is obtained in accordance with the law of evidence, on which basis the court establishes presence or absence of circumstances sustaining demands and objections of the parties and other circumstances relevant for the proper consideration and resolution of the case. Types of evidence in civil proceedings. 1. explanation of the parties and third parties. 2. Witness statements. 3. Written evidence, that is document. 4. Physical evidence. 5. Audio and video recording. 6. Expert and specialist opinions. In civil proceedings, each party must prove the circumstance to which it refers as the basis of its claim and objections, unless otherwise provided by federal law. The court determines which circumstances are relevant to the case. Each party should prove them and bring their circumstances up for discussion, even if the parties did not refer to any of them. Each person participating in the case must disclose the evidence that it refers to as the basis of its claims and objections to other persons participating in the case within the time limit set by the court. Otherwise, the relevant fact may be refuted. For example, when the party refused to submit the original document for examination. All evidence is subject to verification and evaluation in the terms of relevance, that is, must be relevant for the resolution of the case. Admissibility, that is, the circumstance of the case, which in accordance with the law must be confirmed by certain means of evidence, that is, cannot be confirmed by any other evidence. Reliability, that is, compliance with the truth, lack of falsification, distortion, and altogether sufficiency, that is, to resolve the case. Now let us look at the fourth aspect, court proceedings. The civil trial consists of 4 stages: preparatory, consideration of the merits, debate of the parties, decision and announcements of the decision. Preparation for the trial includes deciding whether to accept the claim, that is application, or leave it without movement to eliminate shortcomings, or return it if they are not removed. Notifying interested parties, appointing a court session, inviting the parties to disclose evidence, explaining their rights, requesting certain evidence by the court on the basis of requests by the parties, petitions, or on their own initiative, and so on. The relevant decisions are set out by the court in the definitions on the acceptance of the claim for production, on the appointment of a court session. The consideration of the case on its merit consists of 2 parts. First, the preparatory part of the trial, that is, opening the session, checking the appearance of participants in the process, removing witnesses, announcing the composition of the court, and explaining the right of challenge and other rights and obligations to persons participating in the case, resolving their statements. 2. Investigations of the circumstances of the case, report of the case by the court, explanations of the parties, research of other evidence, application and resolution of petitions, research of the case materials. The parties' debates have their final statements on the merits of the case. The first speaker in the debate is the plaintiff, his representative, then the defendant, his representative. After the debate, participants can make remarks. The right of the last remark always belongs to the respondent, his representative. The decision is made by the court in the consultation room. The court is obliged to announce its operative part, and the production of a full reasoned text has 5 working days. That is, the magistrate makes the full text only if the party's request is submitted in a timely manner. You can appeal the court's decision on appeal within 1 month from the date of making the decision. And with that, we come to the end of the 18th lecture. Thanks.